Derek Ross.
Good morning, Justices. As an NGO with special consultative status with the United Nations, Christian Legal Fellowship wishes to bring an international law perspective to some of the issues that are before you today. And to that end, I plan to briefly address 2 points. First, the right to autonomy of religious communities is a fundamental principle recognized in international law. Canada has committed to uphold that principle through its international commitments. The present case demonstrates a need and presents an opportunity to affirm that principle in Canadian jurisprudence. And second, as the international cases demonstrate, in the event of an internal religious disagreement, the solution is not to coerce a religious community to accept religious practices, beliefs, procedures, or members contrary to its will. With respect to the first point, as you've heard this morning, a central consideration in this case is the freedom of religious communities to determine and administer their internal affairs without interference. And there is strong international support for this freedom, which has traditionally been referred to as church autonomy, more recently as the autonomy of religious communities, or simply religious autonomy. International jurisprudence recognizes religious autonomy as a key component of both freedom of religion and of freedom of association, and as a requirement flowing from the duty of state neutrality. It is therefore understood to be a core characteristic of a free and democratic society. And Canada has committed to uphold a number of international treaties that affirm this principle. These include the Vienna Concluding Document, which is at tab 1 of our condensed book, which guarantees the autonomy of religious communities to organize themselves according to their own structure. The Universal Declaration of Human Rights and the International Covenant of Civil and Political Rights both protect freedom to practice religion in community with others, and these have been interpreted by UN bodies to protect the internal workings and decisions of religious communities from state interference. Further guidance can be drawn from the European Court of Human Rights. That court has interpreted provisions of the European Convention virtually identical to the UN documents I just mentioned. And that court has held that the principles of state neutrality and religious autonomy prohibit state actors, including courts, from interfering with membership decisions or criteria of religious communities, and that the autonomous existence of religious communities is indispensable for pluralism in a democratic society. The second point is this, that in the event of an internal disagreement, religious autonomy may be seen as competing with other interests and claims, but the solution is not to coerce that community to accept procedures or beliefs or members contrary to its will. Such coercion harms not just the religious community, but, as the European Court has held, it interferes with the proper functioning of democracy itself. So the overwhelming majority of cases before the European Court, and we've highlighted some of them in our condensed book, have upheld religious autonomy against competing claims. In the Ukraine case at tab 2, for example, the court rejected arguments that an individual's right to manifest his religion superseded a church's membership requirements. Instead, the individual's freedom of religion is exercised by his or her freedom to leave the community. In the Romania case at tab 3, it held that individual freedoms of association and religion do not give rise to a right to dissent within a religious community, and that religious communities must be free to respond in accordance with their own rules and interests to internal disagreements. And finally, in the Bessarabia case at tab 4 of our condensed book, the European Court held that forcing believers to worship with those outside of their community is a fundamental rights violation, even if the state thinks that doing so is necessary to preserve peaceful unity and social cohesion. There are compelling underlying reasons for these decisions, which we spell out further in our factum, not the least of which is that the autonomy of religious communities is necessary for the individual freedoms of its members. That unless communities are free, believers cannot be free. And this benefits society as a whole, not just believers, but unbelievers as well. To conclude, jurisprudence rooted in Canada's international commitments and similarly worded documents reflect an established pattern, a pattern that jealously guards religious autonomy, particularly in the context of membership decisions and self-definition. This is a basic standard agreed to by a community of states, including Canada, and in our submission should be the minimum standard of protection afforded by the Charter.
Okay.
Subject to any questions. Thank you.